and as pleaded in the statement of claim. And thirdly, the amendments sought to enable the claimant to insert the omitted relief complaint and as pleaded at paragraph 40 in the statement of claim respectively. The amendment thought will help this court to do substantial justice between the parties in this suit, and that by Order 26, Rule 1, 2, and 3 of the rules of this court is empowered to allow desirable amendments in the interest of justice of the case. And the leave of this court is required in the circumstances to enable the claimant effect the desired amendment in the claims endorsed in the complaint and as pleaded as paragraph 40 in the statement of claim. And lastly, that it will be in the interest of justice to grant the relief sought herein. This application came up for hearing on the 21st day of October 2024, and counsel for the claimant, Christopher Asefiti, identified the application filed on the 29th day of November 2023, and is accompanied by a 6-paragraph affidavit deposed to by one informed Ita Itoduko, a litigation secretary in the law firm of counsel for the claimant. And attached with the affidavit is Exhibit A and the written this application. The claimant applicant stated in on the 24th day of October 2022, in which the claims in the during the trial of this case. During the trial, can you hear me?
Yes, my lord.
Yes, my lord.
During the trial of this suit, that he inadvertently omitted to include the said relief sought to be added to the claim endorsed in the complaint and as pleaded in paragraph 40 in the statement of claim, that except the desired amendment is granted, the course of action will be negatively affected by the omission in the claims, that the grant of the amendment thought will help the court to settle the real controversy and do justice between the parties in this suit, that the amendment thought, when granted, will enable this honorable court to effectively and effectually decide the issues between parties. The proposed amendment thought to be made by way of an additional claim in the complaint and as pleaded at paragraph 40 in the statement of claim will not occasion any calling or recalling of witnesses or further giving of any evidence by the claimant. That the amendment thought is already supported by paragraph 39 of the statement of claim, and that a party may only be allowed to correct defects or insert omission in the process if cogent reasons are adduced. The leave of this honorable court has to be thought and obtained in the circumstance to enable a party make any necessary amendment in the originating process as in this case. That the amendment thought in this application will not prejudice, embarrass, or overreach the defendant. That the proposed amended complaint and the statement of claim are annexed and marked as Exhibit A. Counsel urged this court to grant the application. The defendant respondent stated in their counter affidavit that the defendant filed her statement of defense on the 27th day of January 2023, which process was, with the leave of this honorable court, amended on the 16th day of June 2023. and the amended statement of defense was served on the claimant's counsel on the 26th day of June 2023. Parties concluded their cases before this honorable court on the 25th day of July 2023, whereupon the defendant filed her final written address dated 9th day of August 2023 and served same on the claimant via her solicitors on the 11th day of August 2023. That as at the 17th day of October 2023, when this matter came up for adoption of final written addresses, the claimant was yet to file her written address and was already out of time in doing so. The claimant has not applied for extension of time within which to file her final written address in this matter. That on the 29th day of November 2023, the claimant filed a motion seeking for leave to amend her claim by adding an additional claim to the complaint. Although the claimant stated in paragraph 3D of her supporting affidavit that the amendment is desirable to bring the relief endorsed on the complaint in line with the evidence already adduced and led by the claimant during the trial of the suit, but that the claimant did not, however, disclose the evidence allegedly so adduced at trial to support the amendment now sought, and that by the rules of this court, leave to amend is not granted as a matter of course, and as the parties seeking same must adduce cogent and compelling reasons in support of same. If this application is granted, it will overreach the defendant because the claimant is already out of time in filing her final written address by a significant period of time, having failed to comply with the rules of this court to seek for extension of time within 7 days to the end of the initial 21 days, and as such, granting this application will occasion a further delay in the already protracted matter and it will work grave injustice against the defendant. Counsel urged this honorable court to refuse this application for the interest of justice. Counsel for the claimant applicant nominated a sole issue for the determination of this application, to wit, whether the claimant applicant has given cogent and all material facts for the grant of the relief sought before this honorable court. While counsel for the defendant respondent nominated a sole issue for the determination of this application, to wit, whether, given the circumstances of this case, the honorable court ought not to dismiss the application of the claimant for being made malafide. The issues nominated by parties are germane to the determination of this application, and I consolidate the two issues and adopt them in the determination of the merit of this application. So I will skip your legal arguments, which you canvass in your addresses. So I will go to the decision section.
Go, please.
I have carefully analyzed all the processes filed by parties. May I start by saying that amendments to pleadings are ultimately to enable the court to decide the real issues in controversy between the parties. It is to prevent the court from giving judgment in ignorance of the facts that should be known before the rights of the parties are finally decided. See the case of CBN against Dine, Oforishare against NGC Limited, Rotimi against McGregor, and Enibokan against AI Company Limited, and the case of Salami against OK, all citations provided. To ensure that parties do not abuse the right to apply for amendment, Order 26 of the National Industrial Court of Nigeria Civil Procedure Rules 2017 provides for when the application for amendment can be granted or refused. For the avoidance of doubt, Order 26 Rule 1, 2, and 3 provides, and I quote, an amendment may be allowed where its purpose is to determine the real question or issue between the parties and will A, secure substantial justice, or B, settle the controversy between parties and related issues. Subsection 2 provides an amendment may be refused where it will A, present a completely different case or cause injustice to the other party, or where the application for amendment is brought malified, and B, instead the hearing of further evidence, especially on appeal. C, not cure the defects in the procedure thought to be cured, or where it is inconsistent and useless, and D, where it will amount to overreaching the other party or an abuse of the process of court. And subsection 2 of Order 26 provides a party may at any time, but not more than twice with the leave of court, alter, amend, or modify the party's originating and all other processes, provided that the party may not completely change the course of action endorsed on the process, unquote. In essence, An application for an amendment will be granted where it is aimed in ensuring substantial justice or settling the issue in controversy between the parties. The question that arises here is, will the grant of this application settle the issue in controversy between the parties before this court? The basis for the application for amendment, according to the claimant applicant, is that there is a need to add a relief to the reliefs already endorsed on the complaint as pleaded in paragraph 40 of the statement of claim for just distermination of the suit. Additional relief thought to be added is a desirable amendment as it will properly bring the relief endorsed on the complaint in line with the evidence already adduced and led by the claimant during the trial of this suit. However, the defendant respondent in its counter affidavit stated to the contrary, that the claimant filed a motion seeking leave to amend his claim by adding a claim to the complaint. Although the claimant stated in paragraph 3D of her supporting affidavit that the amendment is desirable to bring the relief endorsed on the complaint in line with the evidence already adduced and led by the claimant during the trial of this suit. The claimant did not, however, disclose the evidence allegedly so adduced at trial to support the amendment now sought. I have carefully placed the affidavit evidence before this court on the spectrum of acceptable consideration. The nature of the amendment sought by the claimant applicant will not require the recalling of witness. Neither will it require the defendant respondent to make a consequential amendment to its pleading. It is important to stress that once the calling of evidence has been concluded, any amendment of the pleadings or claim can be justified or allowed only on the premise that the evidence in support of it is already on record. And so it is necessary and the interest of justice to allow the amendment to make the pleading or claim accord with the evidence already on record. The rationale is that such an amendment should be allowed to enable the court to use the evidence already on record to settle the real issues in controversy between the parties. See the case of Shell Petroleum Development Company Limited against John, and also the Court of Appeal in the case of Ikenu against Lokumbo, alluded to Inameka Agu JSC in the case of Umonike and others against Age of Bender State and others, where it stated as follows, and I quote, "It is necessary to state that although by the rules of amendment, an amendment to the pleading can be made at any stage of proceedings, different considerations apply depending on whether the amendment is being thought before or after the close of evidence by parties. But once the calling of evidence has been concluded, any amendment of the pleadings or claim can be justified or allowed only on the premises that evidence in support of it is already on record. So it is necessary and the interest of justice to allow the amendment in order to make the pleadings or the claim accord with the evidence already on record to settle the real issue in controversy between the parties." Unquote. Though the defendant respondent argued that the amendment sought by the claimant applicant will overreach the defendant respondent. The claimant states in paragraph 3D of her supporting affidavit that the amendment is desirable to bring the relief endorsed on the complaint in line with the evidence already adduced and led by the claimant during the trial of this suit. But the claimant did not, however, disclose the evidence allegedly so adduced as trial to support the amendment now sought. I suppose the demand of the defendant respondent is so inconsequential, and the defendant respondent did not demonstrate to this court how the grant of this application will overreach the defendant respondent. The fact that a claimant seeks a relief does not automatically mean that the court is at the mercy of the claimant or parties to grant it. The court will use the pleadings and evidence placed before it to determine whether the reliefs are legally grantable. Thus, the reason the application of this nature will be refused is that the grant of same will require further amendment by the adverse party or recalling of evidence. Given the foregoing, the claimant's applicant's application is meritorious and it is hereby granted as prayed, and ruling is hereby entered accordingly.
I thought pleadings. My Lord, we are most grateful. Thank you, my Lord.
Yes, Abiodun.
I'm sorry, my Lord, I missed the last bit of this, so I didn't hear the ruling that was there. It was frozen here, but we're grateful to the court.
Yes, I granted the application as prayed. That's the last.
Very well, man.
Yeah.
Very well, man. Well,
yes.
Yes, my lord, we have a motion to regularize our final written address. Fine.
Dated and filed when?
It was dated and filed on the 4th day of December 2023.
Yes, Abiodun. Are you opposed to the application?
I'm not opposed to the application.
Yes, Christopher, move in terms.
Yes, my lord, in the absence of any opposition, we move terms. Most grateful.
In the absence of any opposition and rely on the provisions of Order 70, Rule 1 and Order 57, Rule 4 of 1 of the Rules of this Court, I found the application meritorious and I grant the application judgment of time filed by the claimant's applicant on the 4th day of December 2023, and I grant all the prayers as contained on the face of the motion paper.
As God
As it
pleases.
was-
My lord, we are most grateful.
Yes, Abiodun.
Yes, my lord. We are ready to proceed with the adoption of our written address. With the kind permission.
Yes, go ahead.
Okay. My lord, the defendant's final written address is dated 9th of August. It's dated the 9th day of August 2023 and filed on the 10th of August 2023.
Yes.
Where the defendants have formulated a sole issue for determination by this honorable court, to wit, whether the claimant had successfully proved her case to be entitled to the relief sought.
Yes.
Yes. My Lord, have argued claimant has not proved the case to be entitled to the relief. We adopt our final addresses. We adopt our final written address, and we urge this honorable court to dismiss. Oh, I'm sorry, my lord. I don't know if I should do the two together with the reply on points of law.
Yes, you have a reply. Let's go ahead.
Very well, my lord. We also, in response to the claimant's written address, we also filed a reply on points of law. Our reply on points of law is dated the 6th day of December. It's dated 6th day of December, 2023.
Yes.
And it was filed on the 7th day of December. It was filed on the 7th day of December, 2023.
Yes.
We adopt our written address and our reply on points of law as our oral argument in support of the defendant's case in this matter. And we urge your lordship to dismiss the claimant's case in its entirety.
Yes.
We're most grateful.
Christopher.
My Lord, the claimant's final written address is dated and filed on the 4th day of December 2023.
Yes.
And deemed properly filed and served on the 31st day of October 2024.
Yes.
Well, we adopt the said address as our legal argument in support of the claimant case. Normally, urge this honorable court to enter judgment in favor of the claimant as endorsed on the complaint. We are most grateful. Thank the court behind me. Most grateful.
Yes. Yes. Where is that our diary? I think give me the new one. January. Today is 31st. January. Yeah, we did the 30th January. Have you checked 30th January? Okay. Yes, I will give you the 30th day of January 2025 for judgment.
I've got business.
As the court
My Lord, we
pleases.
are most grateful.
We are most grateful, my lord.
Yes. So this matter, I adopt all the processes filed by the respective parties in support of their respective arguments, and I adjourn this matter to 30th day of January 2025, God's willing, for judgment.
As court business.
As the
My
court
Lord, we are
pleases.
most grateful. Yes. Well, we apply to vacate the courts.
Go ahead, arise.